Good morning, sir. Are you Jeremiah Davis? And this is 250066. And Mr. Davis is charged with assault on a peace officer. And what is the announcement?
Your Honor, we're asking for a little more time. We have an offer on the case, and he wants to bring me some discovery that he thinks would help the prosecution get different evaluation. And so I told him he needs to call me this week and make an appointment. He's called me before, but I think he's just been able to get this information.
Mr. Smith, any issue?
No.
All right, so Mr. Davis, I'll reset your case about 30 days. Make sure you get that done early on. Don't wait till the last minute before court so Mr. Parker can get what you have. He can get it to Mr. Smith, and then we can see where we get the next court date. All right, you're free to go, sir.
In a brief but telling courtroom exchange, Jeremiah Davis appeared on a charge of assault on a peace officer as both sides agreed to pause the case, not for delay, but for review. The defense requested additional time after Davis claimed to have newly obtained evidence that could impact how prosecutors evaluate the case. The judge granted a 30-day reset, stressing urgency and cooperation, making it clear this window was an opportunity, not a stall tactic. With the state raising no objection, the moment highlighted a rare shift in momentum, where a defendant's actions outside the courtroom could influence what happens inside it. For now, Davis walks free, but the clock is officially ticking.
Mr. Shetley, in cause number 240776, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from October 22nd of 2022. What that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 2 years up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 2-year deferred probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right. And Mr. Parker, you're hired, correct?
Yes, ma'am.
All right, Mr. Parker, we'll begin preparation for trial, and we'll get it set on the next available trial docket.
One thing, Judge, I think I have all the discovery that I need to confirm. In the discovery, it references a flash drive that was provided to the Gross Police Department. And I don't know if that's some of the discovery I have or if there's actual flash drive that I need to get a hold of. And one of the things is the photos, if I can get it. Yeah, the computer doesn't finish it.
Okay, perfect. All right, thank you. Stay in touch with Mr. Parker. He'll tell you when you need to be back.
In a decisive courtroom moment, Mr. Shetley formally rejected a plea deal in a serious degree felony family violence case, fully acknowledging the risk of 2 to 10 years in prison if convicted at trial. The judge carefully confirmed that Shetley understood both the consequences and his options, emphasizing that the rejected offer, 2 years of deferred probation, was no longer guaranteed. With retained counsel ready to proceed, attention quickly shifted to trial preparation, including unresolved discovery issues involving a flash drive and photographic evidence. The exchange underscored a critical turning point where certainty was traded for principle, and strategy replaced negotiation, reminding everyone that once a plea is refused, the courtroom moves forward with no rewind button.
Good morning, sir. You're Charles Young, and this is 250102, and you're charged with burglary of a habitation. And Mr. Wilkerson, what is the announcement?
Judge, we're going to ask, I'd like to request one more announcement setting. Still working on some information, and there's some additional information also that I need from the DA.
Okay. Has there been any issue with regard to bond conditions, Ms. Malfino?
No, Your Honor. Well, if you recall, there was a hearing.
Yeah, that's what.
With regard to that matter, I'm still trying to get the evidence behind that hearing. So, in terms of what was alleged, pictures, screenshots, messages, anything related to
uploaded off Discovery.
Okay. All right. Sounds like it's all been
uploaded. Just so the court is aware, it has come from the complainant calling the front desk making a report for Nay to me. I just found that motion not be punitive against the defendant, but just to make sure the court was aware, so there could be a no contact for both of the parties either way, and everything I have.
Perfect. All right. So, Mr. Young, I'm going to reset your case about 30 days. Make sure you stay in touch with Mr. Wilkerson so we can try to get an announcement at the next court date. All right. Thank you, Mr. Wilkerson.
In a brief but telling courtroom exchange, Charles Young's burglary case was reset as both sides acknowledged unfinished business behind the scenes. Defense counsel requested more time to gather key information from the prosecution, while the state confirmed that discovery tied to bond condition concerns, including messages, screenshots, and reports from the complainant, had already been uploaded. The judge focused less on fault and more on order, approving a mutual no-contact safeguard and emphasizing communication moving forward. With no bond violations alleged and evidence still being reviewed, the case was pushed out 30 days, another reminder that progress in court isn't about speed, but about preparation, clarity, and keeping control before small issues turn into bigger consequences.
Good morning, sir. Are you Shahram Omid?
Yes.
And this is 241684. Mr. Omid is charged with solicitation of prostitution, and it looks like there was an application for pretrial diversion.
Yes, Your Honor. We
What's the
submitted that.
Uh-huh.
We haven't got a return, Your
Okay.
Honor, but we're all willing to set this case for plea in the event it doesn't come back favorable to my client.
Okay. So what I'll do is one more reset. Mr. Smith, would you please get with, I guess, Mr. Canal or whoever is doing those up there, and if so, we can get an answer before that next court date. That way you can get an answer. Either way, it'll get taken care of either
Yes,
with
sir.
the pretrial or with the plea on that next court
Thank
date.
you.
Thank you, sir. Stay in touch with your attorney. He'll let you know when you need to be back. And if it does get accepted, there will obviously be some other things where you'll need to go sign contracts and things like that. So if he gets accepted and the contract signing is after our next court date, y'all let me know. I'm not going to make you come. You don't have to come here.
Okay.
So we can reset it till after that to make sure all that gets taken place and
Yes, sir.
taken care of. Okay.
Okay.
So just keep us, we'll set it for 30 days, but let me know where things stand. Thank you.
Thank you.
All right. You're free to go, sir. And sir, are you Celine Reinhardt? And will your client waive the formal reading of the indictment?
She will.
Ms. Reinhardt, you're charged with the second-degree felony offense of assault on a peace officer from December 22nd of 2024. And how do you plead to that charge? Oh, I'm sorry. Yeah, I see now. Hold on. Y'all are going on a lesser included, Class A.
Yes, she will.
In this calm but consequential hearing, Shawam Omid's case took a familiar crossroads in the justice system between resolution and escalation. Charged with solicitation of prostitution, Omid stood as the court reviewed his pending application for pretrial diversion, a program that could quietly end the case without a conviction. With no decision yet from the state, the judge granted one final reset, making it clear that the next court date would be decisive, either acceptance into diversion or a move toward a plea. The tone was measured, even accommodating, but the message was firm. Opportunities like this are time-sensitive, and accountability doesn't pause forever. In court, patience is granted, but only when progress is being made.
All right. So in 250089, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest from December 22nd of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Shalander? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Ms. Reinhardt is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court and you could be found guilty of the offense and sentenced to the Jefferson County Correctional Facility for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom, and the probation, she's at that desk right there. She's going to call you up in a few minutes to go over your paperwork, and you're going to help get that attachment.
Seriously.
Okay, thank you. All right, thank you.
Okay.
That's between y'all. It's your job, but if he's going to do it, then it just has to be done today because once the case is closed out, you can't get to the portal. So that's why we need it, just so y'all make sure. Good morning.
In this decisive courtroom moment, Selene Reinhardt's case reached a carefully structured resolution shaped by accountability and restraint. Originally facing a serious second-degree felony charge for assault on a peace officer, the state elected to proceed instead on a lesser Class A misdemeanor of resisting arrest, significantly reducing the stakes. Reinhardt entered a guilty plea knowingly and voluntarily after confirming full understanding of her rights, the evidence, and the consequences, including waiving her right to appeal. The judge emphasized both sides of the agreement. A 1-year deferred probation and a $500 fine offered her a rare second chance, with no conviction on her record if she complies fully, but also a clear warning that any violation could result in jail time. The exchange underscored how the system balances mercy with responsibility, making it clear that leniency is not forgiveness. It's an opportunity that must be earned.
And Mr. Lattiellis was previously in court, entered a plea of guilty to driving while intoxicated third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
None from the defense, Your Honor.
Are you sure?
Well, he does take responsibility for it. We did review his BAC level at the time of the stop, and
So here's the thing, Mr. Lattiellis. Your BAC was 0.229. 0.229. What you said in here is that I'd had a drink the night before, but not that day, and that you hadn't eaten anything. So you're saying you had a drink the day before, and you were at 0.229 when you got this. That doesn't make any sense.
I went and stayed at a friend of mine's house, and we stayed up, barbecue, and drank till probably 4 a.m.
Okay.
And then went to bed.
Okay. All right. Anything, Ms. Malfino, then?
No, Judge, only if this court thinks that the probation is appropriate. I understand. Feel the need to change that as well.
and we are. I did speak with Mr. Nichols about the 10 days. If Mr. Lattiellis could serve him on the weekends.
Are you working, Mr. Lattiellis?
No, ma'am.
All right.
He has a disease that he sees doctors weekly for, and so that was the reason.
And I know Mr. Nichols did discuss his medical condition with
And
last week.
in the therapy.
Right, your physical therapy.
Yeah.
All right. So what day are your doctor's appointments and therapy on the same days each week?
No, ma'am, my therapy's daily. I have a device prescribed that I use 2 hours in the morning and 2 hours in the evening.
Okay. So, I mean, that's something that you're going to have it taken care of in jail anyway, even if it's weekends, right?
I don't know if they'll let me bring the device in.
What is your schedule? What is your weekly schedule with the doctor and the
Well, I'm seeing 3 different doctors. The therapy's daily, and I see one doctor once a week, one doctor bi-weekly, and then one monthly.
Okay. So what I'll do, you're just gonna have to get it figured out with the jail if they do or don't allow that device in. If not, you'll have to work it out where you're just without it for a couple of days. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. I'm going to suspend that, place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That will include 10 days mandatory upfront time. I will allow you to serve that on weekends. You will be required in order to report to the Jefferson County Jail to start that this Friday, June 27th at 6 o'clock p.m. And so you have to be there at 6 o'clock. You need to be on time. If you're late, it's a violation of your probation. If you show up under the influence, a lot of people think they're going to show up under the influence and sleep it off over the weekend. That's a violation of your probation. You'll be right back in here. And you'll do those weekends from Friday to Sunday until the 10 days are satisfied. I am going to order that you enter and successfully complete the Jefferson County Drug Intervention Program. That's the JCDI program. It's an outpatient treatment program to make sure that you have all the tools necessary to stop drinking and stay on probation and not end up in prison. If you don't make it successfully through that program, you're going to end up right back in here looking at the 10 years. Do you understand?
Yes, sir.
You're also ordered to have the auto ignition interlock device. Do you already have that on your vehicle?
No,
Doesn't drive.
I'm not driving.
Okay.
My truck's not even legal. I don't have insurance on it.
So as long as you're not driving, obviously you don't have to have that, but you're not allowed to drive any vehicle. So you can't borrow a vehicle or rent a vehicle, nothing like that unless it has that device on it, okay?
Yes, sir.
So again, if you do everything you're supposed to while you're on probation, this is a good opportunity because for all practical purposes, your case here in court is over and you'll serve that 10-year term while you're out on probation. The other side to that, again, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 10-year sentence that you agreed to. Do you understand?
I do understand.
And I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. Good luck to you, sir.
And there it is. Another day in court where lives hang in the balance and choices carry weight far beyond these walls. We saw pleas entered, probation offered, and the fragile hope of a second chance resting on compliance, honesty, and timing. Each defendant walked away with a path that could lead to redemption or to consequences that can't be undone. And in the silence after the gavel falls, one question lingers in the air. How would we face our own decisions if the eyes of justice were fixed on us?